Serious conflict is an inevitable part of doing business. When a contract fails, a partnership fractures, or a workplace dispute boils over, there's a predictable human reflex. We want justice, and we usually assume that means saying, "I'll see you in court." Before it gets to that point, people often try fixing it internally by going to management or HR. But those systems are built and paid for by the organization they are supposed to police. If one side feels the process is biased toward the company, talks usually break down. Once a dispute enters the court system, it gets trapped in an arena governed by strict rules and backlogged dockets. The resolution timeline stretches into years, while compounding bars represent the escalating legal fees paid just to keep the process moving. And while that meter is running, your privacy disappears. Court proceedings and records are entirely open to the public. Sensitive personal data, financial histories, and proprietary business secrets are suddenly exposed for anyone, including your competitors, to examine. The process is engineered as a binary, winner-take-all battle. It forces the two parties to attack each other's credibility until a judge declares one the victor and the other the loser. That rigid structure practically guarantees the permanent destruction of whatever professional or personal relationship existed before the lawsuit. Between eroded privacy, fractured relationships, and the drain on cash flow, the default litigation reflex often leaves both sides poorer. Even the side that ultimately wins the case walks away having lost years of productivity and thousands in non-recoverable costs. There is a structural alternative. External dispute resolution, or EDR, is a private system that utilizes an unbiased, neutral third party who has absolutely no ties to the conflict or the organizations involved. The system operates on three pillars that directly counter the flaws of litigation. Without formal court rules, you maintain strict cost control. The timeline shrinks dramatically, with resolutions measured in days or weeks rather than years, and the entire process operates with absolute confidentiality. EDR is a flexible toolkit where you control the neutral party's authority. In mediation, they only guide, leaving the agreement entirely to you. In conciliation, they suggest solutions and reality check your case. In arbitration, an expert evaluates facts and issues a legally binding award. This framework allows individuals and businesses to perfectly calibrate their strategy. You can secure a binding solution without surrendering your fate entirely to a judge. However, this system only functions under one specific condition. It requires the voluntary, mutual participation of both sides. If one party refuses to cooperate or negotiate fairly, the private process collapses. There are strict legal boundaries where traditional litigation is still required. EDR cannot be used for cases involving criminal acts or a history of abuse. In those situations, physical safety and state intervention are paramount. It is also the wrong environment for situations involving a massive power imbalance. A private, closed-door setting without judicial oversight might allow a much stronger party to coerce a weaker one into an unfair agreement. And if a dispute involves an issue where a new legal precedent needs to be set, it must go through the public court system to update state or federal law. EDR is the optimal engine for fixing the vast majority of everyday conflicts, while the traditional court system remains the necessary final backstop for protecting the vulnerable and establishing public law. Look at how courts resolve problems. They are restricted to one remedy, taking a complex grievance and awarding monetary damages, but EDR allows for customizable solutions. You can alter a contract, issue an apology, or redesign workflows. This flexibility is vital because paying financial damages rarely fixes the root cause of the conflict. Custom remedies allow professional relationships to survive the dispute, so normal operations can resume. Accessing these custom remedies requires you to actively select your own EDR provider or mediator, rather than being assigned a random judge by the state. This matrix outlines the exact criteria for evaluating a provider. You need to review their credentials, confirm their area of specialization aligns directly with your dispute, and ensure their mediation style matches your desired outcome. It also pays to choose local, specialized providers. Working with someone operating in your specific regional landscape, like Kansas, for example, ensures they understand the nuances of local uniform arbitration acts and state laws. Leveraging external dispute resolution moves conflict from a public courtroom into a strategic, private negotiation. It gives you the power to bypass the litigation trap and solve disputes quickly, efficiently, and strictly on your own